26 Meta employees say they finally learned how people were chosen for this year's layoffs, and according to their lawsuit, it wasn't a manager. It was a scoring system, allegedly fed by their keystrokes, their activity data, even how much they used AI tools. And the workers flagged for firing? People on medical leave, new parents, pregnant women. Meta denies every word of it. And in 10 days, a federal judge weighs in. This is the first big legal battle over AI choosing who loses their job. 26 workers versus a $2 trillion company over a question that affects every American with a job. Can an algorithm decide who gets fired? Part 1. The score. May 2026. Meta begins cutting roughly 8,000 jobs, about 10% of the company. Layoffs happen everywhere. What made these different, according to the lawsuit, is how the names were picked. The complaint alleges Meta used internal AI systems and algorithmically assisted performance rankings, built on keystroke and activity monitoring, and even dashboards tracking how many AI tokens each employee used. In plain English, the lawsuit claims a machine watched how much you typed, how much you clicked, how much AI you used, and turned you into a score. And here's the core of the case, in the lawsuit's own words. Those scores, quote, by design, cannot be accumulated by an employee who is on protected medical or family leave or whose output is reduced by a disability. Translation: if you were out having a baby or fighting an illness, the machine saw zeros. Part 2. The people. Who are the 26? According to the filing, 8 women who took maternity or pregnancy leave, 4 fathers who took parental leave, a woman who took bereavement leave. Every single one of them, the suit says, took protected leave or requested a disability accommodation in the 2 years before the cuts. And the stakes weren't just paychecks. In court, their lawyers argued the workers stood to lose stock options and health insurance in the middle of pregnancies and active medical treatment. One lawyer put it in a single sentence, quote, there's no do-over for bonding with a new baby or giving birth or having active medical treatment. 8,000 jobs, 10% of one of the richest companies on earth, and 26 people arguing the machine that scored them was blind to the law. Part 3. The fight. July 13th. The 26 file suit in federal court in Oakland, California, citing the Family Medical Leave Act, the Americans with Disabilities Act, the Pregnancy Discrimination Act, and the Pregnant Workers Fairness Act. Some of the oldest worker protections in America aimed at the newest technology in the world. Round 1 went to Meta. On July 17th, Judge William Orrick refused to freeze the layoffs. The separations went ahead 5 days later. But he didn't throw the case out. He said raised, quote, serious questions. And he set the real showdown, the preliminary injunction hearing, for August 24th. That's 10 days from now. Part 4. Why this is about your job. Zoom out because Meta is just the biggest name in a much bigger wave. By this summer, American tech companies had cut roughly 140,000 jobs in 2026 alone, with Amazon, Oracle, Meta, and Microsoft accounting for nearly 50,000 of them. And more of those decisions lean on the same thing: activity data, rankings, algorithms. Courts are already circling this question. Rulings against Workday have said an AI vendor can be on the hook for discriminatory hiring screens. And remember the Air Canada rule from our earlier story. A company is responsible for what its software says. This case asks the harder version. Is a company responsible for what its software decides? If the 26 win, every company using activity scores and AI rankings for layoffs inherits a new legal risk and a paper trail requirement. If Meta wins, the message is just as loud. The algorithm stays in the room when the layoff list gets made. Either way, the way Americans get fired is being rewritten right now in one Oakland courtroom. And if you work anywhere near a system like this, the practical lesson from the filing is simple. Keep your own records, your leave dates, your accommodations, your reviews, because the 26 could only bring this case at all because they could show exactly when they were on leave and exactly when their scores fell. August 24th, one courtroom, 26 workers, and the question of whether an algorithm can end your career. We'll cover the ruling the week it lands. This is the AI Signal, real stories about AI, money, and power. Subscribe. so you don't miss round 2.